the criminal appeal, it may be listed on 7th, Lordship.
Not 7th,
7th of November, Lordship.
someday. 7th, I think we'll have truncated list. Maybe after.
No, unlisted
next week.
Lordship, it may be listed on 7th, Lordship.
Not
I am giving the mention slip, Lordship.
7th will have some problem any day thereafter.
Then 10th, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of IA.
Actually, Master, can it be on Tuesday? 11?
11. Lordship.
11.
Yeah, Lordship.
Lordship, listing of IA in connection with Criminal Appeal 200 of 24, and it was last posted on Lordship 10/1/2025.
In 1. Okay.
10/1,
Give it to the court master.
Lordship. Deeply obliged.
Objection file.
Fine.
Lordship, I like to mention item number 19. Kindly matter may be adjourned for the day.
Item number 19.
19, yes.
Okay, on the request of Mr.
Yes, Guru.
S. Guru, Learned Counsel for the appellant. Case the appeal stands adjourned for 2 weeks. Yes, Ms. B. Bhuya, Learned Senior Counsel and additional public prosecutor for the respondent state, who is present, has submitted that state has no objection. The state has no objection to the prayer.
Any other request? Daily list for admission. Item number 1.
This criminal appeal is referred against the judgment dated 5/9/2024 and an order on sentence dated 10/9/2024. Passed by the court of Session Judge Soraido Nari in sessions within regards CHA law, case number 11 of 2022. By the judgment, an order dated by the judgment and the order on sentence, the trial court has convicted two accused persons, including the accused appellant hearing, for the offense under section 302, Indian Graduate section 34, IPC. The accused appellant intends to undergo imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of sessions of case number 11 of 2022 be called for. Issue notice returnable in 4 weeks. As Mr. R.R. Kosik, Learned Additional Public Prosecutor, has appeared and accepted notice on behalf of the respondent state, issuance of formal notice. The respondent state is dispensed with extra copy of the memorandum of appeal in 2 working days. This is the case after 4 weeks. The name of Ms. P. Agarwal and Ms. S. Nath, the learned counsel for the appellants, are to be reflected in the cause list.
Uh, My
Admitted. Okay.
Lordship,
And
I
Ms.
did
P. Agarwal. P. Agarwal.
Lordship, item number 3 had already been admitted.
Item 1.
You are P.
P.
Agarwal.
Agarwal, Lordship.
In this case also, item number 1, your name is reflected in the case record.
I might have missed out. It's not in the
P.
cause
Agarwal,
list.
R. Kaushik.
Lordship, it may be registry may be directed to reflect.
I
on
have
the
said already. Name of so-and-so.
Item 2,
Art, Mr. K. R. Borua. Learned counsel for the accused appellant and Mr. R. Kaushik. Learned additional public prosecutor for the respondent state. This criminal appeal under section 415, Bharatiya Nagarik Suraksha Sanhita 2023 is preferred against the judgment in order dated 4/10/2024. Passed by the Court of Learned Session Judge, Kamrup Metro at Guwahati Trial Court. In Sessions Case number 188 of 2021. First up. By the judgment in order dated 4/10/2024, the Trial Court has convicted the accused appellate for the offense under section 302 Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 30,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. So we have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case record of Sessions Case number 188 of 2021 be called for issue notice, returnable in so and so. Again, agonist and review R. Kaushik as a peer accept.
Lordship, my name may be reflected.
The name of Mr. K. R. Borua,
As legal aid
legal aid counsel, learned legal aid counselor, is to be reflected in the cause list.
item 3,
May it please your Lordships. Lordships, this appeal has already been admitted by your
Yeah,
Lordships by order
P.
dated
Agarwal, learned
23.
for the appellant, and Mr. R. Kaushik, learned additional public prosecutor for the respondent state. First up, the criminal appeal has already been admitted on 23/5/2025. Full stop.
Lordship, I have a short submission to make in this matter. Lordship, arising out of the same impugned judgment, another appeal is also pending before your Lordships since the year 2024, and LCR has already been called for in that matter. So I pray that that matter and this matter may be tagged together. It's criminal appeal number 103 of
As per
2024.
office note dated 27/10/2025, the TCR has not yet been received. Stop. Ms. Agarwal has submitted that another criminal appeal, criminal appeal number,
Criminal appeal number 103 of 2024.
Arising out of the same
Impugned judgment.
judgment of the trial court, has already been admitted, wherein the TCR TCR is also called for. Stop. Both Ms. Agarwal and Mr. Kaushik have submitted that since both the criminal appeals have arisen out of the same judgment of the trial court, this appeal will be listed along with criminal appeal number so and so. After 4 weeks. Let us see if TCR received or not.
If it could be after 2 weeks, because paper book preparation will also take some time. The
But
impugned
are you
judgment.
sure TCR has been received in the other case?
Lordship, we had cross-checked
3
the
weeks after 3 weeks.
deeply obliged, Lordship.
item 4 for orders,
Is your Lordship?
Chakraborty,
Yes.
Service complete here.
Heard, Ms. H. Chakraborty, learned counsel for the accused appellant, and Mr. R. R. Kosik, learned additional public prosecutor for the respondent. Number 1, State of Assam. Full stop. As per office note dated 19/8/2025, service of notice upon the respondent number 2 is complete. Full stop. None has appeared for the respondent number 2 till date. Full stop. As the TCR is already received, officer the registry to prepare the paperwork, post of release the case after 4 weeks for a report as regard readiness of the paperwork.
Items 5 and 6.
May it please your lordship. I am appearing in item number 5, lordship.
Yes.
Criminal appeal number 469 of 2023. Your lordship, my interlocutory application is pending with a prayer for suspension of sentence and releasing him on bail, lordship. That may be considered to your lordship.
The other option is to hear the appeal. Preparation of paperwork is complete.
Preparation of the paperwork is complete.
It can be hard expeditiously, that is one option.
Lordship may fix it on Thursday, lordship, in that case.
Not this Thursday. This is
He is already in custody for 2 years, therefore I am paying, lordship.
next week, any day, any
Tuesday.
hearing day. We'll see that an endeavor will be made to hear the appeal. In the event the appeal is not heard, then the interlocutory application will be considered. Or who can hear? Yes, otherwise ready? But I-
Otherwise, ready.
Okay.
One more aspect is there, lordship. Probably on that day, I do not know whether hearing will be done or not, because lordship, another co-accused is also there. 3 persons were convicted. Here, lordship, two appeals are before your lordship. So in that case,
What is the other appeal pending?
so I have no instruction on that, lordship.
How many have been?
Three
Convicted.
convicts are there, lordship.
Now one already died, man.
No, one died, but another.
Let us see the operative part of the judgment in the paper.
That your lordship will find page 102 of the paper.
102.
Lordship.
Rahman Ali, Sahidul Ali, Tarap Ali.
Yes,
We are, Tarap Ali is there, Sahidul Ali.
yes.
Rahman Ali, any
No,
information?
that lordship instruction we do not have.
You are for
I'm for Sarapali, man.
Tarap Ali.
And my learned finish for, no, I can take it.
Okay.
Whether Rahman Ali has preferred any appeal?
That probably, let's say I have seen one criminal appeal is there, but
Any idea about the number?
that number,
Myself. Yes, Mr. PP, do you have any idea?
But I don't have.
180.
Rahman Ali. Rahman Ali.
informant's name is
Here to some.
Rahman to মৰিছে
Here to some.
জহিৰুল মৰিছে, চাৰিজন আছে। ৰহমান মৰিলে এপিলটো কেনেকে ফাইল কৰিলে? এপিল পেণ্ডিং আছেতো। সেইটো আৰু এটা
Who is the informant?
পূৰ্ণিমা lordship.
Oh, same. Then it is same.
Yes, that's why I thought.
Then it is same.
Yes. We do not know whether that paper book has been received or not, because I have checked that order. They said lordship LCR received in connection with this case.
Rahman.
Same submission to
Submission to the
paper book.
Name of the advocate. Very good. Pratham order. Pratham order. Twenty-four, 2024. Since it is my order, the details should be there, I am sure.
That was the submission I had checked yesterday night.
Arjun Mia.
নবিছে সেই মেইন ড্ৰাইভাৰটো গাড়ীত পাঁচজন আছিলে তেনেহলে ৰহমানে জেলত থাকোতে মৰিব পাৰে
Rahman Ali.
Lord, as per our information, my lord, the accused Rahman Ali was died by.
Also, he preferred the appeal as per my learned friend is saying, Lordship, that Rahman Ali died.
Rahman Ali died.
That appeal which is pending. Probably therefore on last occasion, no one appeared for that.
Huh? Last order to Saksundar. What is it, sessions case number?
Sessions case number, Lordship, 173 of 2016.
Right, same judgment. Now last order to Saksundar. Mr. P. Bora. Mr. P. Bora. P. Bora.
We হেৰি কৰি লম চাৰ্টিফিকেট ফিক্স কৰি লম জেলৰ পৰা ইনষ্ট্ৰাকশ্যনটো লৈ আছো
ঠিক আছে
We have made an alternate prayer, Lordship. Lordship may fix it on 6th, and by this time he will obtain the instruction from jail authority whether Rahman Ali died or not. And in the meantime, both the cases may be tagged and listed, Lordship.
Would it order Saksundar, Your Honor? He is okay, let all the cases be listed together.
On 6th, Lordship, and by this time he will obtain the instruction whether that person died or not.
কোনখন জিলাত আছে
Kamrup.
Already there is an order. What is this?
In that, there is an order to take the matter along with these cases.
Along with this case, already there is an
There is
order.
an order. Probably it was passed on,
469.
recently passed for probably that was,
That was in on 3/9/2025
yes, probably day after holiday.
in that order. Okay. And if paper book is ready in case of criminal appeal 469, then same can also be used in relation to the present appeal. So that appeal. So everything is same. All are to be hard together then.
Only issue is that this my learned friend said that he died, that has to be asserted.
Then Mr. P. Bora, if he appears, everything will be clear.
And he may also obtain instruction also by this time.
my lord.
Heard Mr. A. Ahmed, learned counsel for the appellant in 5. Mr. R. Ali, learned counsel for the appellant in 6. As well as Mr. R. R. Kosik, learned additional public prosecutor for the opponent state. Full stop. These two criminal appeals have arisen out of a trial court, have arisen out of a judgment. Dated 28/11/2023 and an order on sentence dated 30/11/2023 passed by the Court of Learned Additional Session Judge number 1, Kamrup Metro Guwahati in Sessions case number 173 of 2016, posted by the state judgment and order on sentence, comma, 3 accused appellants, three accused persons including the present two accused appellants, have been convicted. Full stop. The third convicted accused has also preferred an appeal, criminal appeal number 180/2024, which has been admitted by an order dated 10/6/2024. And in the said appeal, an order was passed on 3/9/2025, to list the appeal along with criminal appeal number 469/2023. As as the same paper book will facilitate the hearing of the appeal, hearing of the appeals arising out of the same judgment and order of the trial court. In view of the same, list these two appeals along with criminal appeal number 180/2024 on 12/11/2024. It is submitted at the bar that the appellant in criminal appeal number 180/2024 might perhaps have expired. Or Mr. Kaushik, learned additional public prosecutor shall make endeavor to obtain information regarding the accused appellant Muhammad Rahman Ali from the officer in charge of Senga Police Station.
Probably he is jail lodged in Kamrup jail, district jail, Kamrup Metro.
And stroke or district jail,
Kamrup Metro.
Kamrup Metro, to place the information
180/20.
on the next date of listing. List these two appeals along with criminal appeal number so and so on 12/11.
Item 7.
The same set of evidence. Incluye details of the order to issue a warrant. Sorry. Mic to mic.
May I please, Your Lordship?
1 minute. Yes,
My Lordship, matter may be passed over for the day, Lordship.
pass over for the day.
Yes, Lordship, my senior is out of station. Leave notice also.
Who is your senior?
Mr. HRS Auto.
Both A. Ahmed, all are here. Ayu Chaudhary, A. Ahmed, all are here. All
Right.
arguing counsels.
In fact, tomorrow, Lordship.
Huh?
Tomorrow, Lordship.
Mr. Chaudhary is arguing counsel, Mr. Ahmed is arguing counsel,
Hello, in fact, this
A. Ahmed.
matter can be fixed for final disposal, it seems, my lord. Other side is also appearing, my lord. Paper book is also ready.
We don't know, all these weeks cases are fixed, so we can only put it someday.
Lordship, make
It
it
is
tomorrow,
not-
Lordship.
It is for IA or what?
Aye, Lordship.
Okay.
কালি বেশি না।
Praise made for adjournment. Okay, next Wednesday, put it on next Wednesday. Miss
S. Nazneen.
As Das,
Nazneen.
Nazneen, learned counsel for the appellant, Mr. R. Kaushik, learned
He was.
additional public prosecutor for the respondent number 1, State of Assam, and Mr. D. Chaudhary, learned
Good night.
counsel for the respondent number 2 are present, post of on the request of Miss Nazneen, learned counsel for the appellant, which is not proposed by the learned counsel for the respondents, list the case on next Wednesday.
Next to that. So, this is-
Holiday.
Item 8.
Item 8, I need some accommodation, my lord.
No steps,
My lord, actually, I have not gone through the record.
not sincere.
My lord,
State appears to be not sincere.
my lord,
13/11/2024. 1 year back,
1 year wait.
notice was issued for delay of 300 days. State was directed to take steps within 3 working days.
My lord,
As per office note, no steps.
my lord, take instruction from the office and then.
No steps, it is there.
Yes, my lord.
In the
seems, my
office
lord.
note.
Seems.
Either you take steps
We'll take steps.
or don't press the appeal.
We'll take steps, my lord. But we,
Mr.
within-
R. Kaushik Laran, additional public prosecutor. Peruse the office note dated 13/5/2025, post up, wherein it is reported that no steps. For
my lord,
service of
because
taken.
in my,
No steps for service of notice upon the opposite party has been taken in reference to order dated 13/11/2024. Post office. Mr. R. Kaushik Laran, additional public prosecutor, has sought 1 week's time to take steps for service of notice upon the opposite party in reference to the order dated 13/11/2024 by speed post. Also, the prayer is accepted, lays the case after 4 weeks.
as per my, here in our file, my it is written, my lord, on 1st of this month, my lord. 1/11/25 steps.
You
were
have taken steps.
Yes, my lord.
Okay, Mr. R. Kaushik Laran, additional public prosecutor, has submitted that steps for service of notice have been taken on 1/11/2025. First of the office to examine the above aspect and first of lays the case after a week for report as regards taking of steps by the state, by the state.
Item 9.
Mr. Das, let it be some, before, I am not taking up all these cases.
No problem. We'll make a prayer for registry to list it. Your lordship will indicate that not,
Place this appeal for a bench, before any other bench, we don't. It is for what?
I,
I'll
Leasing,
list,
all-
as sought for. Please to place the case on a date in the next week.
there is some, we'll make a
On
prayer.
a
Your
date in the
lordship
next
will,
week.
your lordship will not pass any other order because your lordship is not taking up. So we, is appropriate that we'll make an application for registry.
Lordship, on last occasion also, our name was directed to be listed in a cause list.
That's the whole problem.
Lordship,
That your lordship, I think your lordship will indicate.
the name of P. Kotoki
P. Kotoki.
and PP Dottom.
The name of Mr. P. Kotoki, learned,
Special public prosecutor.
public prosecutor. And you are there also.
Lordship, PP Dotto,
And
additional,
Mr. P.P. Dotto, learned
additional special public prosecutor.
additional special public prosecutor are to be reflected in the respondent side in the cause list.
Obliged, Lord.
There was some urgency, but I will not trouble this court because your lordship is not taking up. Better that your lordship will not pass any order. We'll make a prayer there. I'm deeply obliged.
Obliged.
Item number 10.
I appear there's some consultation, some of the accused, and that's why I'm not taking up all these cases. Somebody was pointing finger.
May please, your lordship. That's your IS for delay of
IA for?
28 days. Delay, lordship, 28 days delay is there and service complete.
Service is complete. Heard Miss L. Devi, learned, learned legal aid counsel for the applicant appellant. And Mr. R. R. Kosik, learned additional public prosecutor for the opposite party, that's respond number 1, comma, State of Assam, full stop. The instant application under section 5 of the Limitation Act 1963 is prepared seeking condonation of delay of 28 days, comma, which had occurred in preferring the accompanying criminal appeal, comma, criminal appeal J number of criminal appeal, accompanying criminal appeal, full stop. The accompanying criminal appeal is preferred against a judgment and order dated 27/8/2024, passed by the Court of Learned Additional Session Judge cum Special Judge within bracket POXO, Morigaon, in POXO case number 167 of 2022, by the judgment and order dated so and so, comma, the trial court has convicted the applicant appellant for the offense under section 6, comma, protection of children from sexual offense effect, and he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for further 3 months. Convicted for the offense under offenses under section 376 AB, comma, Indian Penal Code and section 6. After sentence under section 6 POXO sentence. Full stop. We have gone through the statements and averments made. You are legal aid counsel, right?
Yes, sir.
Legal aid counsel. We have gone through the statements and averments made in the instant application from a more particularly comma. Paragraph 3, 4 and 5. 3 to 6 thereof, full stop. The applicant appellant, in our considered view, comma, has been able to explain the period of delay of 8 days, showing sufficient cause, full stop. In any view of the matter, as the applicant appellant has been sentenced to undergo imprisonment for 20 years, right? Comma, the appeal, the appeal, it is deemed proper to hear the appeal on merits after the hearing of the appeal on merits will subserve the cause of justice after condoning the period of delay which is not significant. Full stop. In the above view of the matter, the instant application seeking condonation of delay of 28 days in preferring the accompanying criminal appeal is allowed. Full stop. The registry to list. Full stop. As condoning the delay. Full stop. The respondent number 2, despite the opposite party number 2, despite service of office, has not appeared. Full stop. In any view of the matter, comma, the respondent number 2, the hearing of the appeal will be done after serving of notice upon the opposite party. That's respondent number 2.
Item 11.
May I plead your service is completed.
Mr. A. Paul, learned counsel for the appellant is present. Mr.
A Nayak. A Nayak.
N.
A Nayak.
A. Nayak.
Yes.
A. Nayak.
Yes.
A. Nayak, learned counsel, has submitted that he has entered appearance for the sole respondent, full stop. As the TCR has been received and the sole respondent has appeared and comma and the appeal has already been admitted for hearing on 6/8/2025, comma, the registered is the case for hearing in due course.
Interim order.
Interim order
To continue.
shall continue.
And my lord, one more prayer.
The
My lord,
interim order passed. I
Yeah,
shall continue
the-
till the next date of listing.
the respondent was directed to pay maintenance of rupees 3,000. In view of some Lok Adalat order settlement between the parties. So let, the new maintenance may kindly be given to the petitioner who is not able to run herself.
Shall remain suspended. What is, Miss
Yunanda.
Nanda, learned counsel for the appellant is present. Please note, indicate notice was issued on there is no return. In view of the office note dated 31/10/2025, await for the service in respect of the sole respondent. This is the case after. Full stop. The office to place the case, appeal case before the law Jima court to ascertain the status of service of notice upon the sole respondent and for report. This is a case after 2 weeks.
Item 13.
In this case, Lordship, service is complete, however, TCR not yet received.
Okay, heard Ms. B. Sharma, learned legal aid counsel for the accused appellant, and Mr. R. Kaushik, learned additional public prosecutor. Comma, Assam for the respondent number 1, comma, state of respondent number 1, comma, state of. Full stop. As per office note dated 24/7/2025, comma, service of notice upon the respondent number 2 is complete. Full stop. As per office note dated 4/8/2025, the TCR has not been received. Full stop. Office to send a reminder for the TCR. Raise the case after 3 weeks.
Item 14.
Mayor,
Heard Mr. A. Gogoi, learned legal aid counsel for the accused appellant, and Mr. R. Kaushik, learned additional public prosecutor for the respondent number 1, comma, state of Assam. Full stop. The from the yes, Mr. PP, you have to obtain a report.
My lord, next date may be given, I will take
Steps.
instruction.
For service of notice upon the respondent number 2 has been taken as per office note dated 21/6/2025, steps for service of notice upon the respondent number 2 have already been taken. Full stop. The learned additional public prosecutor shall obtain a report from the officer in charge, Panay Police Station, as regards service of notice upon the respondent number 2 to stroke informant to place the same before this court. Before on the next date of listing, list the case after 3 weeks. TCR received, as TCR has been received, comma, the office to prepare the paperwork.
Item number 15.
My lord, item number 15, can it be? Can it be passed on for the time being? My lord, my colleague B. Pune is looking into this matter, my lord.
May it please your lordship. This matter, your lordship, is an application under section 5 of limitation or a delay of 31 days, your lordship. Notice was issued on the last occasion.
Not, the service report is not available. Okay. Mr. Y.S. Menon, learned counsel for the appellant. Within, is present, first of. As per office note dated 30/10/2025, comma, neither regard nor answer notice has returned. Returned back after service. Post. It was only sent on 23/10. So
Very late.
await for the service report, release the case after 2 weeks.
Lordship.
For hearing, item number 17.
Second time is in too long. Second time is not. Push on my push.
This also down.
Actually.
Wait, that will not have a presumption.
They call but it's so Worship, before my learned friends start my dot, can I
Yes.
fix on next week or I could not prepare properly this case. Actually, I got the paper book today morning, my lord.
Mr. Chakraborty, you are ready.
Other was ready anyway, since my friend is there,
What is the case?
because he is in undergoing for the last more than 11 years, Lordship.
Oh.
My lord.
Is it?
Lordship. Anyway, Lordship, since. my
Anyway,
friend
we
is-
can start hearing.
My
302, if it is 11 years,
Lordship.
then this should be given precedence. 11 years. Okay, just we'll have a look.
Lordship.
Any eyewitness?
No, Lordship.
No eyewitness.
Only one has says that PW2, but whether that is reliable or not. Because there will be many points which I would like to point out, because they said that 2% has been injured. The one who has been.
Let us see the
only-
FIR,
Lordship.
then I will understand.
Lordship. Page 4, Lordship. Of the paper book. May I read, Lordship?
Hmm.
I have the honor to state that I am a poor woman from Krishnapur under jurisdiction of your police station on 12/8/2000. Our neighbor Sri Ranglal Bhumij assaulted us without a cause and started quarreling with us. In the evening, he assaulted me and broke my left hand. Sri Lalu Karmakar also sustained grievous injury in one of his hands. When my younger brother Kanu Karmakar came to disengage us from this couple, he was badly assaulted and left at the court. He has passed away last night. I therefore.
Yes, Stefali was examined.
Several was PW1, Lordship. Now, her statement only one line, Lordship, page 9.
No,
The second line.
we'll read first.
This-
Okay, just a minute.
Here at the fourth line, she said about the tea leaves that has not been reflected in the FIR.
This Ronglal Bhumis is the son of daughter of my
They are related. They are related.
maternal mama. Mama's Wali's son.
So her cousin,
Kanai
it will be her cousin.
was
I think.
my younger brother.
Mhm.
Kanai Karmakar is diseased.
Kanai Karmakar is the disease.
Was my younger brother. More than Phula. And child Phula. Took Ronglan, Ghanu. In between.
Now this brother Aganu and assaulted, that is not reflected in the FIR.
Not, FIR is not required to be
Lordship. In any case, Lordship.
encyclopedia.
That's true, Lordship.
To the road to tell Ronglan that he too should not engage in at the same time.
He was taken to the hospital, but the Kanai was not taken. Why?
Ronglan's behalf.
Lordship, in the cross, second last statement is important, Lord. I told the police that I did not know who assaulted my younger brother, Kanu Karmuk.
She was medically examined?
Yes, or simple.
Who is the doctor? Who is the doctor?
PW9.
PW?
By PW9, Lordship. It will be page 20 of the paper book.
When the FIR was lodged?
14th.
8. Okay.
Incidents is up to 12, Lordship. He suggested X-ray report has not been examined, whether
But
they are
injury is
simple in nature.
whatever, but the injury is there.
Injury is
And
only her.
if she is injured,
Informant.
if she is injured, then he comes in the pedestal of injured witness.
Lordship.
Then the standard of an injured witness testimony is different than a normal witness.
Plus 323 is applicable.
Look, let
Lordship.
us see. Yes, no. Okay. She is the only eyewitness.
Only I said, but what you have stated in cross, the Lordship has diminishes.
Which one?
Second last inner cross. I told the police that I did not know who assaulted my younger brother, Kanu Karmukar. Second last statement in cross, Lordship.
And who is his medical evidence? Autopsy doctor?
Autopsy. Page 17, Lordship. And one line is important, content of alcohol was there, Lordship. And other witnesses stated that he was a habitual drunkard, Lordship.
No suggestion
No, sir.
to the autopsy doctor
Not,
that are falling on hard surface.
Lordship. That's
Huh?
true, Lordship. But
The defense counsel,
is alcoholic.
no, that is a different thing.
Lordship.
But declined.
But this postmortem report doesn't is contradict the Lordship inquest report. In inquest reports, the police
No,
state,
because see, homicidal in nature, this is an opinion.
Lordship.
Homicidal in nature, so it should have been, there should have been some suggestion
Of course, Lordship.
that falling on hard surface from
That's true.
a height,
Height.
that should have been there.
That should be.
Lalu. Lalu was referred in the FIR.
Lalu's name.
I think in the FIR, Lalu was mentioned somewhere. Lalu, what does Lalu say?
Lordship, PW2. Only he says that in cross, when I was
Let me
writing,
read this, let me read that. This part is wrong. Kanai died after 2 days.
Lordship.
If you see that the doctor examined him on dead body
Lordship.
on 14, I think, where is the autopsy doctor?
PW6. Page 17.
PW6. 14 itself.
Lordship.
This part is wrong. Kanai died after 2 days.
Lordship. And Lordship,
He
he
said
met-
the incident took place on 12.
and
One
Lordship,
minute. One
Lordship,
minute.
and he said that incident happened in front of 2 persons. His name. Those 2 persons has not been produced as a prosecution witnesses. Mali Bhagat,
12-8.
Mali Bhagat and Chauhan, Bhadram Chauhan. Police neither recorded the statement
He
nor
says Kannada 2 days.
only he said in cross Lordship when I was running away.
Died in July, August.
After his death, the fire was, after he died on the
FIR was lodged on?
14.
14th, after his death.
After his death. Yes, FIR was lodged after his.
This story, hey, FIR of Johnson.
Well, data incident occurred as well. I see.
1 minute. Side action put aside. Side action put aside. Oh, you can.
This PW1 also stated that I do not know who wrote the FIR.
That is why inconsistency. Bhola. The Bhola was mentioned.
Bhola is PW8.
Somebody, yes, grandchild. Bhola. He is how much old? 18 years.
And no injury report of Bhola and Lalu. And Bhola said in cross, I did not see who assaulted Kanai. That is a statement of Bhola. And Bhola did not support that tea leaf story in his chief lordship. He rather said he was playing with one Sam Bin when Rangolal assaulted him. That loading of the story is not there in his statement. And he also admits that he took his grandma in a sumo vehicle.
1 minute. Let me read it.
Lordship.
So you elicited by cross-examination
Lordship, that,
from PW2
Lordship.
that while I was running away,
Is the only statement come out.
right, you elicited.
Lordship. Whether that is, now Lordship, whether that has been.
You did not
supported-
cross-examine the autopsy doctor.
Lordship, that's
Then
true.
you elicited this.
But are there no other witnesses has supported that, Lordship? Because Bhola said, I did not see who assaulted Kanu.
No, Bhola said,
Lordship.
Bhola said,
He was
Bhola
present
said. No, we have to match the all. Bhola said, he said, when assaulted, each of us ran away to different direction. I did not see who assaulted.
Lordship.
And
But one thing, Lordship.
PW2 said also that Bhola escaped injury, Bhola ran away.
Lordship.
So he could not be assaulted.
He said he received 4.
Bhola also said, I did not get hurt.
But
his submission is believable.
But PW2 says 3/4 blow he received, but no injury report. Lordship.
Mayor non-examined, but his presence was,
And one thing,
his presence there going together was by Sefali also, he also, and Bhola also. And plus Kanai, all 4 went together.
that has not come up in his chief, Lordship.
No, we have to.
And one thing, Lordship, from Bhola, it's appeared that the vehicle can go down to Sefali's house. Why? Kanai was not taken to hospital.
That is,
Lordship.
the choice is there.
Maybe, but those things,
A
Lordship,
doctor with surname Singh from our village provided treatment to Kanai Karmakar.
or no,
Kanai was administered saline and injection.
Lordship,
Right.
Lordship. But one is what is he has to have been taken. And it has come out from evidence that he was ill for quite some time. That others have stated so. Her own Sefali's
Whether
husband.
Kanai and Kanu is same.
Same person.
How can we believe? Say.
Lordship, same person. He's also called as Kanai. Somewhere is Kanai, somewhere is stated Kanu. That PW3 have stated Lordship, Kanai and Kanu both name. He has mentioned.
Quick doctor.
Quake doctor. It has come with Quake doctor, Lordship. And Lordship, if come to PW7, page 18, husband of the informant. He completely diminished. So there's damaged their case, Lordship.
You reduce defense evidence.
Lordship. Lordship, both EW 7 and 8 suggested, supported that he was not keeping well, that Kanai Karmakar was not keeping well. He was suffering for some time. That has been come out from their evidence. And the IO said he has seen only one injury on the backside. And beside that, he had not seen any other injury. And that is what he has reflected in the inquest report.
Contusion of the head.
So in any case, Lordship, even if the one blow is taken to be, I come out with 304 for the already detention already suffered for 11 years, Lordship.
That is what we are examining actually. Hey, IPC concern? IPC.
No,
Mm.
corner because of foreign.
Mhm.
Yes,
Mhm.
different.
What we are trying. Mm. Exception. Four. What is the conviction?
For life, Lordship.
No, for heart also.
For heart, Lordship, 1 year. For 6 months, Lordship. for 323, 6-month lot.
So far, which paragraph?
Lordship 44,
So far that evidence is concerned, it is not dislodged.
Lordship.
The Cephali has
Injury.
deposed, medical evidence, simple heart, 323, that part,
For C got,
that
that
remains.
can be.
That will remain.
That will remain, Lord. Only whether there was intention to, because that, to strike and give blow to Kanai and whether with an intention to cause that.
It is there, that head,
But
head with a lathi,
with the lathi.
that is also there. That
But that is
lathi
not-
can be
but-
fatal.
But the
If
chain,
it is in a sensitive part
But-
of the body. I have understood your,
well, if two views are possible, Lordship.
no, not two views. Head, lathi and homicidal,
Lordship.
that is there. But it looks like, though there was an earlier incident in the morning, the informant side,
Went to
they went
query.
to the Ranglal's house
Yes, Lordship.
to confront and question
Why he has been.
why you have said so. So there appears to be sudden quarrel.
Quarrel.
4 persons here, family members of Ranglal on the other side.
Other side. Scuffle
So-
took place,
It was not Ranglal who came to beat them.
Lordship.
They invited the beating. Right? Had they
Went to
Not-
Cephali's house.
gone to
Cephali.
Ranglal's house, they had gone to Ranglal's house.
Yes, Lordship.
It was not that Ranglal had come to their house.
Lordship.
They had gone to the Ranglal's house. Then these 4 versus his family member,
Lordship.
including him. So it could be definitely a sudden quarrel. Otherwise, it was not his.
Intention,
The Mansriya was not originally before him.
Lordship.
That had he come to his house, Kanai's house,
With a predetermined.
then it was a premeditated thing. It is not premeditated. They had gone to his house,
Lordship.
his family members, and he gave the beating. And not with others, only lathi. And he didn't die immediately,
After 2 days he died.
after 2 days.
And he has not taken to hospital also when
And
Cephali was
he
taken.
has spent 11 years as on death.
But he has taken the life, my lord.
Taken a life? No, I am not saying.
It was on a
It
vital
is a
part.
case of
That Visha Singh, Lordship, whether applicable.
Birsa Singh comes, Birsa Singh will come, but the other factor that
Yes.
he had not come, they had gone
Lordship. That's
to
the-
his house.
My lord.
And it is not single, Kanai, 4. He may retaliate. Yes, definitely there was a quarrel. Some quarrel was there. So it
And
might,
intention, your lordship meant to say it reserved for part 2?
maybe. And period spent
At least 15 years, my lord, minimum.
11 years. We have been giving 8 years, 7 years for 304 part.
Even age, right?
Already
Accused
spent
of-
11 years in custody.
Leave it to your lordship, my lord. And how old is he? 28 years.
Hmm?
28 years at the time of 313, my lord. 2014. 2014, another 11 years, you'd be 31. 28 or 11, kiman hoy? 39.
39.
इसलिए कौन सा है था?
Whatever we can complete, we will complete today. Otherwise, rest Thursday. No?
But 11 years during the trial period also I've not seen, my lord.
No, because this is showing, you can
Oh.
verify. 11 years, 1 month, 14 days.
Oh, sure.
So you can verify. If it is less,
Let it be, man.
when is the offense?
12/11.
2012.
12,
And what is the
12/8,
trial court
2008.
judgment says?
29, 2014.
Trial court judgment. Or deny.
Page 29.
আজি এটা part কৰি থৈ দিওঁ। This is jail or
Isn't
private?
Lordship?
Jail appeal, no?
Jail or
Private.
Private.
Okay. The instant criminal appeal under section 374,
LCA
comma, Code of Criminal Procedure 1973 is directed against a judgment an order dated 20/09/2014 passed by the Court of Learned Sessions Judge Tinsukia Trial Court in Sessions case number 172 within bracket T of 2012. Full stop. By the judgment and order dated 29/2014, the trial court has convicted the accused appellant on 2 counts, comma, for committing the offenses, that is, comma, for committing the offenses under section 302 Indian Penal Code and section 323, comma, IPC. Full stop. The petitioner for the offense under section 302 IPC, comma, the accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for another 6 months, full stop, for the offense under section 323 IPC, comma, he has been sentenced to undergo rigorous imprisonment for 1 month. Oh, sorry. Oh, to pay a fine of rupees 500, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for 1 month. Full stop. The sentences are ordered to run concurrently. Full stop. Para. The prosecution case was set into motion on institution of a first information report by the informant, comma, Srimati Sefali Rajbhor, PW1 bracket, on 14/8/2011 before the officer in charge Philobari Police Station, Posto, in the affair, Commander informant, who was a resident of Krishnapur, comma, had inter alia alleged that on 12/8/2011, comma, her neighbor, comma, Ronglal Bhumis, that is the accused appellant, assaulted them without a cause and started quarreling with them, full stop. The informant further stated that the accused appellant assaulted her in the evening, and as a result, her left hand was broken. Full stop. The informant further alleged that Lalu Karmakar and her younger brother Kanu Karmakar were also assaulted. First of Lalu Karmakar sustained injury on his hand. First of her brother, Kanu Karmakar was assaulted when he came to disengage them from the scuffle. First of, and due to injury sustained, he passed away the previous night. First of para. On receipt of the FIR, the officer in charge, Filobari Police Station, registered it as Filobari Police Station case number 25/2011 under sections 325/302, IPC, within bracket corresponding GR case number 1021/2011, and decided to take up the investigation of the case himself. Full stop. Para. During the course of investigation, the IO conducted inquest proceedings on the dead body of the deceased, Kanai Karmakar, in the house of Virgu
Virgu Rajbhar. Lordship, page 40.
I have seen there it is Pinagu. Now page 18. Birgu Rajbhar.
In 18, it has been mentioned.
Birgu, Pizru Rajbhar, within bracket PW7, as Kanai Karmakar died in his house. Inquest proceeding was conducted in the house of the so-and-so on 14/8/2011.
Investigation period, only for 90 days he was there. Then thereafter he was on previous bail, Your Lordship. I've seen the records. And from the date of judgment, he's there behind the bars.
Is it so?
Yes, my lord.
Date of the judgment is when?
14, Lordship. 29th, 2014.
11, right?
11 years. More than 11 years.
Judgment is of 2014.
Yes, from 14 he is there.
So it is, I think, 11 years. The IO also sent the informant, PW1, who claimed to have sustained injury in the incident, to Filobari State Dispensary on 14/8/2011, and PW1 was examined by PW9, the medical and health officer number 1, Filobari State Dispensary on 14/8/2011. Full stop. Thus, IO recorded the statements of the after the inquest proceeding, the dead body of Kanai Karmak was sent to
Tinsukia Civil Hospital.
Tinsukia Civil Hospital for post-mortem examination. Full stop. The IO drew up a sketch map of the place of occurrence within bracket EXT5 and recorded the statements of the witnesses under section 161 CRPC. Full stop. After collecting the post-mortem examination report and completing the investigation, the IO submitted a charge sheet under section 173 within bracket 2 CRPC by charge sheet number 02/2012 on 31/01/2012, finding a privacy case against the accused appellant for committing the offences under section 325 and section 302 of the IPC. Full stop. On receipt of on submission of charges, the Court of Chief Judicial Magistrate secured the appearance of the accused appellant. Full stop. On receipt of process, the accused appellant, who was earlier granted bail on 18/1/2012, appeared before the Court of Learned Chief Judicial Magistrate, District, Tinsukia, on 18/7/2012. Full stop. The copies were furnished to the accused appellant as per the provisions of section 207, CRPC. Full stop. Finding the offense under section 302 IPC exclusively triable by the Court of Sessions, the Learned Chief Judicial Magistrate Tinsukia committed the case records of ZR case number 1021/2011 to the Court of Sessions, Tinsukia, by an order of commitment dated 18/7/2012. Full stop. The learned additional public prosecutor was notified accordingly, and the accused appellant on as the accused appellant prayed for allowing him to remain on bail, the same was allowed with a direction to the accused appellant to appear before the Court of Sessions on 3/8/2012. Full stop. On receipt of the case record of ZR case number so and so, the Court of Sessions, Tinsukia, within a trial court, registered the same as Sessions case number 172 within bracket T of 2012. Full stop. After the prosecution case was opened by the learned public prosecutor. Full stop. After hearing the learned public prosecutor and the learned defense counsel, and upon perusal of the materials on record, the trial court framed charges under section 323 IPC and 302 IPC against the accused appellant on 19/9/2012 full stop. When the charges were read over and explained to the accused appellant, he pleaded not guilty and claimed to be tried, full stop. During the course of the trial, the prosecution side, examined 10 number of prosecution witnesses to bring home the charges against the accused. First of after examination of after closure of evidence from the prosecution side, the accused was examined under section 30313 CIPC, wherein the incriminating the evidence, the incriminating evidence brought on record by the prosecution side was placed before him for his explanation. First of the case of the where is 313?
Page 27.
The case of the accused was falsity in the prosecution case. First of when the accused was asked as whether he would adduce evidence, he answered in the affirmative. Full stop. Thereafter, the defense side adduced evidence through three witnesses, DW1 to DW3. Full stop. After hearing the learned counsel for the parties and after appreciation of the evidence on record, the trial court returned the verdict of guilt by the judgment and order dated 20/09/2014. Full stop. Hence the criminal appeal. Full stop. We have heard Mr. B. Chakraborty, learned counsel for the accused appellant, and Ms. B. Bhuiyan, learned senior counsel and additional public prosecutor, assisted by Ms. M. Das, R. Das, learned counsel for the respondent state. Full stop. Where Mr. Chakraborty, learned counsel appearing for the accused appellant, has submitted that the version projected in the FIR lodged on 14/8/2011 was a different one than the case sought to be established by the prosecution during the course of the trial. Full stop. He has submitted that the deceased the date of the disease was in the house of
Saif Ali and Vrigu is husband of Saif Ali.
in the house of Birgu Rajbhar within bracket PW7, who is the husband of the informant, PW1. Full stop. The date of the disease was without any medical treatment in a health facility. Full stop. Rather, comma, it has emerged from the evidence or record, comma, the disease was treated by a quack. Full stop. He has further submitted that contrary to the testimony of PW1 that she suffered fracture in her left hand, it has emerged from the evidence of the treating doctor, PW9, that the injury sustained by the informed PW1 was only a lacerated injury, and the nature of injury was simple. Full stop. Though the Lalu Kormokar, Lalu, L-A-L-U, Kormokar, PW2, in his testimony, deposed that he was assaulted by a bamboo stick during the incident, but no medical evidence as regards his injury was brought on record. Full stop. It is his submission that neither PW2 nor neither PW1 nor PW3 had seen who had assaulted Kanai Kormokar. Full stop. From the evidence on record, it has emerged that the prosecution witnesses, PW1 to PW3, along with the deceased, Kanai Kormokar, had gone to the house of the accused on 12/8/2011 to question the accused as to why PW3 was assaulted by him along with his associates in the morning hours of that day. Full stop. Mr. Chakraborty has thus submitted that it was not the accused who had come to the place of occurrence with any intention to assault any of the prosecution witnesses. Rather, it was PW1, PW2, PW3, and the deceased who had gone to the house of the accused to question and confront him. Full stop. In view of their arrival, the family members of the accused came out. And there was sudden quarrel between the two sides. And in the scuffle, the deceased, the Kanai Karmakar might have received some injury. Full stop. It is his contention that from the medical evidence, it can be seen that the disease sustained only one injury on his person, and he died after 2 days of the incident on 14/8/2011. Full stop. And as per the autopsy report, within bracket EXT, two, the opinion in autopsy report EXT2 that the injury was sustained by blunt force impact. Yes, thus contended that by no stretch, it can be, one can reach a conclusion that the death of the deceased was a homicidal one. And even if it is assumed that in the alternative, he has submitted that even if it is assumed that the death of the disease was a homicidal one, then also it cannot be termed as a case of murder. With such submissions, he has called for interference with the judgment of the trial court. Full stop. Per our contract, Ms. Mia, learned additional public prosecutor appearing for the state, has submitted that the autopsy doctor PW6 had clearly opined in the post-mortem examination report EXC2 that the death of the deceased had resulted due to shock and hemorrhage. Resulting from injuries sustained, and the death was homicidal in nature. Full stop. The disease had sustained the injuries on a vital part of the body, that is a vital part of the body, and he sustained fracture on the frontal bone or the left parietal bone. Full stop. MS Bhuya has further submitted that as the victim had died a homicidal death, his death after 2 days from the date of sustaining injury, sustaining the head injury is immaterial. Full stop. And his death and immaterial. Full stop. তার এই চক্রবর্তীর সাবমিশন লিখে দিও। He has further contended that had the deceased been treated in a health facility, the disease might have survived. Full stop. Ms. Bhuya has further submitted that the accused had caused injuries, submitted that it has emerged from the evidence on record that the accused had assaulted not only the deceased, but two other persons, PW1 and PW3. And therefore, there was clear intention on the part of the accused to cause injury on the deceased on the vital part of his body. Full stop. Yes, anything more?
Lordship might not have, Lordship survived. Probably that observation might have survived.
That is in his submission.
In my submission.
Might have surveyed.
Yes,
surveyed.
no.
I said that
Not sustained, yes.
immaterial.
Might,
His death after 2 days is immaterial.
might.
I have balanced both your submissions. We have duly considered the submissions of the learned counsel by the parties. And have also gone through the evidence, stock materials brought evidence on record, available in the case record of sessions case number so and so, in original. Post. Para. As discussed above, during the course of the trial, the prosecution side and the defense side examined the following witnesses. Table kon asen never. Page 39. And exhibited the following documentary evidence. Page 39. Where? PW, the informant, that's PW1. A lady aged about 70 years. Not like, deposed that the accused was the son of the daughter of her maternal uncle and their neighbor. And the deceased was her younger brother, who died last year. Full stop. As regards the incident, PW1 stated that at around 3 p.m. on the date of occurrence, her grandchild, Bhola, within bracket, PW2, 3.
Bhola is PW3.
3.
Came to her and alleged that, came to her to allege that the accused and
his younger brother, Aghunu, Azhunu, had assaulted him. Full stop. Having heard the same, PW1 stated to have told PW3 not to engage in any quarrel further with the accused. Full stop. Then, she decided to meet the accused to tell him also not to engage in any further quarrel. Full stop. When she went there to meet the accused, his parents, younger sister, and younger brother came and beat her up with a stick on the road. And as a result, as a result of assault, as a result of such beating, her left hand was broken and she lost her consciousness. Full stop. She was thereafter brought back to her house. So later on, she received medical treatment. Full stop. PW1 further stated that the accused persons also assaulted her younger brother, Kanai, and caused grievous injuries on his person. Full stop. PW1 deposed that subsequently, Kanai died at her house before she was taken to hospital. Full stop. Then she lodged the FIR. And police personnel came to the house to take the dead body of Kanai for post-mortem examination. So, during cross-examination, PW1 deposed that she did not remember the date of occurrence. Post of the FIR, she stated that she lodged the FIR when police personnel came to her house on receipt of information from the villagers about the date of Kanai. So she denied the suggestion that her hand was not broken. Suggestions. And that Kanai Karmakar alias Kanu was not in her house since before for suffering from illness. Full stop. PW1 had however admitted that she told the police that she did not know who assaulted her younger brother, Kanu Kormokar. Full stop. Para. PW2 Lalu Kormokar was a cousin of the accused. He's a cousin of the accused and a nephew of the deceased. Full stop. PW, in his testimony in chief, PW2 stated that on the date of occurrence at around 7 p.m. on the date of occurrence, he heard a commotion from the house of her aunt, PW1, who is the wife of his father's elder brother. Post of going there, he came to know that the accused had assaulted PW1. As a result, PW1's PW1 apostrophe S. Left hand was broken. Then he and PW3 went to the house of the accused to ask why he had assaulted PW1. But the accused and his family members surrounded him to assault with a bamboo stick. And in the process, he sustained injury near the right elbow. Vola, within bracket PW3, who accompanied him, had however managed to run away and escaped to be assaulted. PW2 further deposed that the accused had assaulted the deceased with a bamboo stick Mali Bhogat is not a witness, I think. Mali Bhogat. In front of DW is not there. With a bamboo stick, and he fell on the road. PW2 further stated that the accused also assaulted his aunt, PW1, in front of one Bodram, Sohan's house. It was PW8, Sukram Tati, who took Kanai Kormokar to the house of PW 1. But, Kanai Karmakar died after 2 days. On 14th of the month. 14th of the month. PW2 did not remember in which month the occurrence took place. Full stop. PW2, he further stated that as no one was available at that time, Kanai Karmakar could not be taken to any doctor or hospital for treatment. Full stop. Subpara. In cross-examination, PW2 denied a suggestion that he did not tell the police that the accused and the members of the family had assaulted him. Full stop. He stated that he was assaulted at about 8:00/9:00 p.m. and he received 3/4 blows on his hand and on back. Full stop. On being assaulted, he ran away to his house. Full stop. PW2 further stated that when he was being assaulted, Kanai Karmakar reached near the house of one Mali Bhagat. Full stop. PW2 stated to have witnessed the accused assaulting Kanai Karmakar while he was running away from the place. Full stop. And denied a suggestion given by the defense on that aspect. PW2 also denied a suggestion that as Kanai Karmakar did not sustain any injury, he did not undergo any medical treatment. Post stop. Para PW3, Bhola, Goala was deposed that he knew the accused and the deceased, who was his grand uncle. Post stop. Regarding the incident which occurred 1 year earlier, PW3 stated that on that day, the accused hit him on the head and he told his grandmother, PW1, about the assault made on him by the accused. Then, PW1, his maternal uncle, PW2, and Kanai Karmakar, along with him, went to the house of the accused to question him about the assault. Full stop. But before they could ask the accused anything about the assault, the accused and 3/4 members of his family assaulted all of them with bamboo stick and firewood. Full stop. PW3 stated that though he did not receive any beating, PW 2. Sustained injuries, full stop. They then left from the place of occurrence, full stop. Both of them then fled from the place of occurrence, full stop. Later on, the accused persons assaulted PW1 and Kanai Karmakar, full stop. He further stated that PW1 got her hand fractured. Full stop. Kanai Karmakar sustaining injury at the hand of the accused, fell on the road and was lying there. Full stop. PW1 was taken for medical treatment in the next morning, whereas Kanai Karmakar was treated by a doctor in the house itself. Full stop. Kanai Karmakar died 2 days after in the house of PW1. First of after the death of Kanai Karmakar, the matter was informed to the police at Philobari Police Station, Varveli. First of sorry. Line 2022. According to PW3, he and Kanai Karmakar alias Kanu went to Philobari Police Station on the date of the incident itself to inform about the occurrence of Varveli. So the police in turn said that they could have lodged a written FIR. The written FIR was lodged only on the date of Kanai Karmakar. During cross-examination, PW3 stated that all 4 of them went together to the house of the accused to question him about the assault the accused had made on him. He stated that when assaulted by accused and his family members, each of them ran away to different directions, and he did not see who assaulted Kanai Karmakar. The Kanai Karmakar was provided by a doctor with surname Singh, who was from their village only. And the doctor administered saline and injection to Kanai Karmakar. PW3 denied a suggestion that owing to his illness, Kanai Karmakar was receiving treatment in the house of PW1 and the accused did not cause him any injury by making assault on him. PW4, Paramatma Thakur knew the deceased, the accused, and PW1. He, in his examination in chief, deposed that on the date of the incident, he was not in his home, and he learned about the incident. About the incident only from his wife. Posto. On the following day, he learned about the death of Kanai Karmakar. Posto. The PW4 exhibited the inquest report as EXT1 and identified his signature therein as EXT11 full stop. He, however, stated that police personnel came and took his signature on a sheet of paper, and he did not go to see the dead body of the deceased. Full stop. The defense side declined to cross-examine PW4, full stop, para. PW5 is the elder brother of the deceased. Full stop. PW5 stated that the accused is his nephew, being a son of his sister. Full stop. PW5 testified that at about 8 a.m. on the date of the incident, he came to know that Kanai Karmakar was lying in the house of PW1 and PW7 in a critical condition. First up. Going there, he saw Kanai Karmakar lying in an injured condition on a bed with blackened marks of injury all over his person. First up, he met PW2 and PW3 at the house of PW7, and they told him that the accused had caused the injury to Kanai Karmakar by assaulting him with a lathi stick. Post up. PW5 further reports that though Kanai Karmakar was treated by a quack doctor, he died the following day. Police personnel came and after examining the dead body, they prepared some documents and took the dead body for post-mortem examination. Post up. The police person took his signature on a sheet of paper and he exhibited the inquest report as EXT1, which is signature therein as EXT12. Post up. PW5 stated that he did not know the reason why the accused assaulted Kanai Karmakar. Post up. During cross-examination, PW5 stated that he did not, Kanai Karmakar did not die for receiving treatment by a quack doctor, and that it was due to sustaining injury in the incident of assault. Post up. Para. PW6 was the PW6 on 14/8/2011 serving as the senior medical and health officer at Tinsukia Civil Hospital. Full stop. On that day, he performed a post-mortem examination on the dead body of Kanai Karmakar who was brought by police personnel, by a police constable and a relative. And a relative, PW5, post op. PW6 deposed to the effect that on examination of the dead body or a disease, he found the following. Page 17, A, 2A. PW6 further testified that in his opinion, he opined that the death was due to shock and hemorrhage resulting from injuries sustained. So he opined that all the injuries were caused by blunt force impact, and they were antemortem and homicidal in nature. He further opined that the death was 12 to 18 hours earlier than the postmortem examination. PW6 exhibited the postmortem examination report as EXT2, which is signature therein as EXT21, apart from the inquest report within bracket EXT1 post-op. The defense had, however, declined to cross-examine PW6, the autopsy doctor, post-op, para PW7. Complete this tree. Right on. PW7 is the husband of PW1, and the disease is his brother-in-law. In his testimony, PW7 stated that he knew the accused, who is the son of his sister-in-law. He stated that he did not know how Kanai Karmakar died, as at that time, he was at another place. It was on receipt of a message from PW1 through PW3 that he came to learn about a fight between PW1 and the accused. He stated that as the disease was also present at the time of the fight and sustained injuries in the fight, he succumbed to his injuries subsequently. So when he came to the house, he saw the dead body of the disease lying on the floor with injuries on the head, chest, and abdomen of the deceased. During cross-examination, he stated that he could not say whether the disease was present in the marpit, as he did not see it. He, however, stated that the disease was keeping well for quite some time. PW8, who is a co-villager of the accused and the informant, deposed, and the deceased, deposed to the effect that the disease was suffering from illness. Prior to few days prior to the death, his death, there was a quarrel between the accused, Dirku, I don't know, and PW3 and others. subsequently, comma, okay, Dirku is, I don't know. The deceased died in the house of, in the house.
He has mentioned Dirku, it should be Brigu.
Huh?
He has mentioned Dirku, it should be Brigu.
Brigu said, okay, in the house of Brigu, PW7. This man was present.
Lordship, and he,
Huh?
he said, Lordship, he was present at side of.
Oh, he was present.
Lordship.
We did not see it. See, page 19.
And he said Rangalal was not there. Thesis was not there.
Hmm. In cross-examination, PW8 stated that he was present at the time of quarrel, which took place in the courtyard of the accused. Full stop. At the time of the incident, Manoj Chauhan. Who is Manoj Chauhan?
It was just DW, Lordship.
Manoj Chauhan. No, Manoj.
No, he is not. Manoj has not been a witness, Lordship.
Manoj Chauhan, within bracket, not a witness. And his father and Rajendra Bhogat. No, Manoj Chauhan and his father and Rajendra Bhogat within bracket, not witnesses, were also present. And he did not find the presence of the accused.
Thesis.
He did not witness the presence of the accused at the place of occurrence.
This
This is.
Oh,
Lordship.
this
This
is. Full stop. PW8 further stated that the Kanu Karmakar was suffering from illness since about 15 days prior to his death. And he stated about his illness before the police when his statement was taken. Full stop. Para. PW9 was, on 14/8/2011, serving as senior medical and health officer number 1 at Philobari State Dispensary. Full stop. It was on that day at around 3 p.m, he examined PW1. Full stop. PW9 stated that on examination, he found one lacerated injury on the left forearm, which was of approximately 2 cm length, 2 mm breadth, and 2 mm depth. Full stop. He advised X-ray of the left arm of PW1. Full stop. PW9 deposed that the injury sustained by PW1 was simple in nature and was caused by blunt hard object. Full stop. He exhibited the medical examination report as EXT1, which is signature therein as EXT31. Full stop. He further stated that not good. Okay, only IO and all these are the PW10. We'll leave it for the next day. Next day?
4:30, can continue.
Thursday morning. B. Chakraborty. Land Council for the appellant. Aro. B. Bhuya. Are present. I'll raise the case appeal again on Thursday.
6/11.
As part heard. I don't dictate, it will get prolonged. And this bench is for this week only. So we'll dispose of this week only.